Although this is an introduction, I actually just finished reading the order that terminated my parental rights over my two children. My son being, at the time, not quite 3 years old, and my daughter about 10 months. Now, my son in May will be 10 years old, and my daughter 8 in August. But these matters seem to be in trend again. No, not in trend by the morons that constitute the great American zeitgeist. Just in the matters that concern whether or not I get to go to jail with my former husband for crimes, of course, never perpetrated, and probably simultaneously, while he gets found not guilty of the crimes that he undoubtedly did because of the pictures and the criminal complaint, which includes the complaint of his wife number 3. I was number 2, wife number 3. Pictures of her body covered in head to toe with bruises, witnesses who saw her jumping out of a moving car to avoid going home with him. No, those are going to be vacated probably, because the wife number 3, she isn't the kind of woman that really gets to say that she doesn't deserve to be hurt. I wasn't either, and still am not. And witness the no mail that is in my apartment, as always, as this is my apartment that I share with myself. And I am Caesar here over my kingdom of one. So it's coming back into my attention as prosecutor wants to talk to me about MO, because he claims that the ex is going to use consent as a defense. Funny thing that the only reason that any man would have consent as a defense to use is if consent as a defense had ever been effective. And indeed, consent was found to be certain, in that my parental rights were terminated for allegedly consenting to being beaten by not having anywhere else to go at the time. So here we are. I'm going to do my best to redact as I read for all the names except mine and my ex-husband's, and know that I relish the opportunity to answer idiotic questions. I relish the opportunity to know of the specious conclusions that folks might come to when they hear about a woman domestic violence victim and her parental rights being terminated. We all assume that it's for something else. They can't have terminated her rights just for being a victim of domestic violence. Oh, but they did, and they do, and they regularly do. And I'm not alone at all. That's the little trick. So when we're discussing domestic violence, maybe we ought to include that. That in this country, a woman can have her parental rights terminated for failure to protect against domestic violence, which would be the same charge that would be leveled in family court against her abuser. Because the words unspoken in that statement, failure to protect against potentially witnessing domestic violence being perpetrated upon their mother in the home. The mother is guilty of failure to protect from domestic violence when she is found to have been beaten in the home in which her minor children reside. They don't even have to prove that they ever witnessed it. Cheers, America. I'm going to come back at you with the tapes that I made just now, the videos, I don't know, that I made, just now, because I had to make a lot of them. It's a big, fat, long order. And if any of you give a shit about justice, you'll stick around while I read the appeal. Mine and then his. If not, if you've already decided that I'm full of shit, although I was right about other things, but not this. Cheers to you. Nobody cares about Tom Hoffler's grandchildren, I guess. I do. My children, that's all I care about. And it's the only reason the Hoffler files even exist. Because if it hadn't been for the multitudes of exculpatory evidence on those same files, I would not have been inclined to expose myself to your judgment. Again. Cheers, America. Know that I am really grateful for a lot of bullshit pity and the victim blame that I reject. Know that I'm really grateful for the no help that's offered me, as to this day I have one single attorney who has offered to represent me in any situation. I can pay. And one co-author, a Canadian law professor who had noticed my case before we'd ever met as a beautiful example of how evidence-based prosecution goes wrong for the victim, and how the victim of DV is re-victimized by the court as her behavior, i.e. being beaten, is criminalized as child abuse, emotional abuse. And once again, why didn't she leave? I don't know what to say. I'm speechless. Imagine that. Well, anarchy is the solution, as we are all equal. All hierarchy can be nothing more than violence. Because to place a person in authority over another devalues one and exaggerates the value of another person's soul. Anarchy is the only solution, as people do not obey laws. People obey their conscience and their own instinct. And if it's wrong, well, they do it. And if it's right, they do it. And whether it's law prohibited or not is shown over time and time again not to have any relevance to the decision to commit such an act. In other words, laws against beating your wife really don't make any decisions for anybody. It won't be until we, and that means you men, because men like this don't respect or think the opinion of any woman has any bearing or has any significance in their life. It's up to the community of men to inform other men that the opinion that beating your wife does not emasculate you is outdated. As long as men feel that beating their wives is a manly behavior, and that in fact going at it against the law just even more manly, until you convince men that beating their lovers, who should be able to trust them, is in fact a very non-masculine behavior, emasculating even, then nothing's going to change. Enjoy. Peace. Fight the power. Okay, here I am. I want to read you all this. I'm going to use initials for the names of my children, and even for the names of the adults involved, which are many, because I don't want to get accused of doing anything other than just, sharing what happened to me. Not lack of confidentiality. Okay, so let's just say that this is in the Circuit Court of Jackson County, West Virginia. Judge TCE III presiding. Juvenile case numbers XXXXXX1 and 2. And no, although we had separate case numbers, my now ex-husband and I were tried in one proceeding. Our cases were not severed, nor were they severed when I requested a divorce. We were tried together. And in the words of the department, if we terminate one of you, we'll terminate both of you, because that's the way they do it, okay? Disposition order. The petitioner being the Department of Health and Human Resources by random person versus ML and BL infants and Stephanie Lizon and Peter Lizon adults respondents. Disposition order. On March 26, 2014 and March 28, 2014, these cases were before the court for disposition hearing. Then they note the appearances, which is basically just the DHHR and a couple of people who were working there at the time, and the special prosecuting attorney, JWD. The infants present by their guardians ad litem, AHA and EBG. The adult respondent, Stephanie Lizon, was present in person and by her attorney, RG, and the adult respondent, Peter Lizon, was present in person and by his attorneys, KWH and DLA, all court appointed. Also appearing were CASA representatives, Nameless Bitch and Nameless Cunt. At the hearing, the court noted that both adult respondents had filed written motions for post-adjudicatory improvement period as required by statute, and the issue before the court was whether to grant those motions and afford the adult respondents the opportunity to correct their abusive and neglectful conduct, which caused their children to be in state custody. The court also acknowledged receipt of the written report of CASA recommending termination of parental rights. In aid of disposition, the court heard the testimony of M.A., who was called as a witness by the petitioner regarding the recommendation of the West Virginia DHHR that the improvement periods be granted. The petitioner presented a uniform child and family case plan containing the terms and conditions of the proposed improvement periods. The petitioner rested. The guardians ad litem moved the court to consider the prior testimony of record in the case, which motion was ordered granted over the objection of the adult respondents. The adult respondents each testified and were subject to cross-examination, as was Dr. T.S., an expert witness called by adult respondent Stephanie Lizon. Thereafter, the court heard the testimony of Dr. R.M., a psychiatrist and expert witness called by the guardians ad litem and who testified by video conference. The court also considered certain documents admitted as evidence, including the psychological evaluations of the adult respondents and the psychiatric evaluation of the adult respondent mother, and certain documents evidencing their attendance at domestic violence education programs and counseling. At the conclusion of the evidence, counsel for Stephanie Lizon withdrew her motion to withdraw as counsel, earlier filed, long story. Based on the pleadings, the evidence adduced at the hearings, the proposed findings, and the argument of counsel, the court makes the following findings of fact found from the clear and convincing evidence and conclusions of law. Findings of fact. 1. This case commenced with the filing of a verified petition on September 6, 2013, alleging that the infant respondents, ML and BL, were abused and neglected children at the hands of their parents, adult respondents Stephanie Lizon and Peter Lizon. The petition was later amended, specifically alleging that Peter Lizon had inflicted serious domestic violence over a long period of time upon Stephanie Lizon in the presence of ML, And as a result, their son had been emotionally abused. It also alleged that Stephanie Lizon failed to protect the children by exposing
ML and BL
to this physical abuse. The amended petition also alleged that Stephanie Lizon had perpetrated abuse on her father, Thomas Hoffler, during a period of time when her parents had guardianship of the older child. Finally, it was alleged that the adult respondents had neglected BL's medical needs by failing to treat a severe yeast infection, otherwise known as diaper rash. 2. After several hours of testimony at a preliminary hearing over multiple days, which included lengthy testimony from both adult respondents, the court ratified and confirmed the removal of the children from the adult respondents, finding quote-unquote imminent danger existed at the time of removal. The court did determine, however, that the petitioner had failed to prove evidence of medical neglect, but did find that the evidence was clear and convincing that Stephanie Lizon was a victim of serious domestic violence in the home at the hands of her husband, that neither adult respondent acknowledged the domestic violence, that the testimony of Stephanie Lizon was not consistent with her injuries, that the severe injuries apparent on her body were consistent with reports that Stephanie Lizon allegedly made out of court, at a women's shelter, in parentheses, that some of the severe injuries on the body of Stephanie Lizon were plainly non-accidental, and that the domestic violence constituted substantial emotional injury to the infant respondents. Citation not necessary. 3. ML, infant respondent, was born on May 29, 2011, and has been in placement since termination of guardianship with his maternal grandparents occurring in August 2013. The grandparents had been granted guardianship in a proceeding consented to by the adult respondents during a period of time when Peter Lizon was under criminal indictment for the violent injuries allegedly inflicted on his wife. However, the grandparents were permitted to relinquish this guardianship after a hearing in this court on August 23, 2013, and the child was placed with DHHR pursuant to Minor Guardianship Rule 15 to determine whether a substitute guardian should still be appointed or given back to us. During the guardianship, which had been in existence for several months, the adult respondent mother was granted limited rights to travel with the child in the Washington, D.C. area, and the adult respondent father was granted only strictly supervised visits. The guardianship was relinquished by the grandparents after the parents were both arrested and jailed. Stephanie Lizon on a charge of child concealment, and Peter Lizon for violating conditions of his criminal bond prohibiting contact with Stephanie. Go figure. 4. Bojana Lizon, who was born on August 15, 2013, was removed from the adult respondents and placed in the same foster home with her brother Moimir immediately preceding the filing of the petition, pursuant to an emergency ratification order signed by the Magistrate Court on September 5, 2013. At the time, she was but 3 weeks of age. Well, after her removal, the adult respondents spoke with the press and were granted front-page coverage about this confidential proceeding in major state newspapers, like the major state newspapers that they didn't have any problem telling a bunch of bullshit to the year before, right? According to the testimony of both adult respondents, BL was conceived during the period of time when Peter Lizon's $300,000 criminal bond was conditioned on no contact with his wife, Stephanie. All right, that's items 1 through 4 of the findings of fact. We'll continue. 5. Both infant respondents have continued in foster care in the same home during the pendency of these proceedings. The adult respondents have repeatedly filed motions to change placement and to impede the ability of the infant respondents to receive needed medical care. How odd. ML has suffered from repeated ear infections, and 2 board-certified specialists have recommended surgical placement of tubes in his ears. No. It's not true. 2 board certified. No. Neither child has been able to be immunized during the placement at the insistence of the parents who do not believe in immunizations. No. My son had already been immunized. He'd already been immunized. So that's why we objected to him being immunized again. Right. Just before Christmas 2013, the adult respondents requested and received an order prohibiting the children's exposure to non-secular or religious activities. The latest motion to change placement, this was Peter's motion coming up here, makes scandalous and unfounded accusations that it would not be surprising if the foster parents' attitudes degenerated into violent or criminal behavior if the department or the court attempted to remove the children from the home. Okay, well, he's exaggerating a little bit on that, I think, but nevertheless, the motion, still his motion, also recites that the children come to visits unclean, wearing ill-fitting clothing, and it expresses that the adult respondents fear that the child Moimir might be subjected to punishment, corporal or otherwise, for showing affection towards his parents and for refusing to show similar affection to the foster parents. I don't really think it was the foster parents that would have, reacted negatively. Who he described as weird people. No, he said that his son might think, who are these weird people, as opposed to his parents. Are members of the Baptist faith, and according to him, it is well known that Baptists believe in corporal punishment. Well, I don't think they are actually Baptists, but I don't really want to hear anyone telling me that the Baptists don't believe in corporal punishment, as was witnessed by the marquee that was up at the Baptist church in our neighborhood when this accusation was leveled, that said, "Today, a switch regulates everything but the children." 2 witnesses, visitation monitor Jessica JQ and CPS case aide TB, both testified that the children come to visits clean and well dressed, in clothing which is suitable for the weather and well fitting. Whatever. After considering the evidence, it is plain that the accusations made against the foster parents by the adult respondents are frivolous, have no evidentiary support, and appear to serve no purpose other than to harass. To ask them not to take our children to church is harassing them. This court heard the testimony of the foster mother at a hearing on March 14, 2014, and was impressed. The court was impressed, noting that the foster family was clearly interested in the best interests of the children. I don't think that that's disputed all that much. Ironically, it is the adult respondent's home where violent criminal behavior has occurred. Really? Criminal behavior? No convictions? And it is Stephanie Lizon, this is good, who appears for visits with her children, and on occasion before this court, with insufferable body odor. Yes, boys and girls. Right here on the page, it says insufferable body odor. Six, the adult respondents made admissions at a hearing on February 25th, 2014. We made admissions. The admissions were made in writing in the form of verified amended answers. In the admissions, Stephanie Lizon advised the court that she had been a victim of domestic violence at the hands of her husband in the presence of the children. You realize that not in the same room, but that they lived in the same house. And that this constituted emotional abuse to the children. Peter Lizon admitted to being the perpetrator of domestic violence, also emotionally abusing the children, by the way, just also. The court specifically questioned Stephanie Lizon about the apparent and complete inconsistency between these admissions and her prior sworn testimony in both this and other proceedings. After assurances that the admissions were freely and voluntarily made, the admissions were accepted. The admissions were accepted. That's like the judge accepting your plea of guilty at the, the trial. After assurances that the admissions were freely and voluntarily made, the admissions were accepted, and the adult respondents were adjudicated as abusing parents and the children as abused children. The case was scheduled for disposition. At the time the admissions were made, the adult respondents were purportedly living separate and apart, and Stephanie Lizon had filed for divorce. By disposition, however, they testified that they had resumed cohabitation upon the advice of their therapists, and the divorce petition had been withdrawn. More on that later. 7. On the day following the adjudication hearing, the guardians ad litem filed an emergency motion seeking to have the supervised visits of the adult respondents with the children suspended. The court entered an ex parte order and rescheduled the matter for further hearing, which occurred on March 14th, 2014. After finding that adult respondent Stephanie Lizon had engaged in intentional, volitional, and willful behavior designed to offend others by coming to 10 of 13 visits with extreme body odor, the court reinstated visits with the requirement that if the adult respondent mother again appeared with the same conditions described in the evidence, the visits were to end. Because ML had exhibited severe emotional outbursts following the visits, including violence directed towards his baby sister and other females, the DHHR was ordered to arrange for the child to be evaluated by a competent independent child psychologist. To date, this has not been arranged, and no child psychologist has ever been identified by DHHR to perform the evaluation. It is important to note that the adult respondent father had attended only 2 visits prior to the disposition hearing, once shortly after the children were removed in September 2013, and the visit which precipitated the filing of the motion. In that time, he had only seen his baby daughter for a total of approximately 3 hours in the nearly 7 months since her removal at age 3 weeks. At the disposition hearing, Peter Lizon confirmed his earlier testimony at the preliminary hearing that he chose not to visit because he did not trust DHHR outside the courtroom. He also admitted, as was heard on the audio recording he made without knowledge or consent of the visitation monitor, we had her knowledge and her consent, that he had compared supervised visits to a concentration camp. He didn't actually admit that he had done that. He used the words that he actually spoke. He had voluntarily cut short his allotted visitation time at the second visit, avowing that he would play only by the rules he thought were best for his children, in italics. Can you believe it? And ending his rant with an expletive when describing rules which had been put in place by the MDT. In the same testimony, he accused one of the guardians ad litem of being dishonest in knowingly presenting testimony which he testified that she knew to be false, an accusation which this court finds is wholly unfounded. Really? 8. The ex parte order suspending visits filed on February 26, 2014 was actually the second time the court had ordered visits suspended. The first suspension came after the petitioner and the guardians ad litem moved the court to suspend when Stephanie Lizon, acting in contempt of the court's explicit order to refrain from breastfeeding BL during visits, had been caught in the act. She later filed a police report that the visitation monitor had battered her when removing the child from her breast. She put hands on me. She laid hands on me. Although no criminal charges resulted, the visitation monitor was replaced by the DHHR. Good move. When the next visitation monitor signed an affidavit for the second motion to suspend visits and testified in the March 14th hearing, she was also replaced as the visitation monitor by the DHHR. Good move, DHHR, to replace a visitation monitor that made crude comments about the fact that I didn't use secret deodorant. The newest visitation monitor has been subjected to numerous and harassing emails from the adult respondents, including one sent at 3:13 a.m., seeking to clarify the visitation rules and asserting that their civil rights have been violated. Seeking to clarify the visitation rules. That they have been unfairly treated by this court and have experienced serious bias and prejudice in this case. Okay. The mother, Stephanie Lison, made clear in her testimony that when she does not like an answer given to her by a subordinate worker at the DHHR, she simply goes to the quote-unquote higher-ups, and that she knows GH, the CPS supervisor, and his boss, MR, the community services manager, on a, quote, first-name basis, unquote. The higher-ups in DHHR have undoubtedly been responsible for the abrupt visitation monitor changes, just the same as being responsible for the recommendation that the court grant post-adjudicatory improvement periods. 9. Both Peter and Stephanie Lison have undergone parental fitness psychological evaluations arranged by their own attorneys at various stages of the case. These were completed by, insert name here, Group PLLC. Stephanie Lison also submitted to a psychiatric evaluation by BMMD at whatever PLLC. Both Dr. S and Dr. M testified at Disposition. Significantly, in their own testimony, both adult respondents admitted that they were not truthful in the information given during their evaluations, as they denied the domestic violence in their home, which they, at the adjudication, admitted. A. Peter Lison admitted at no time to any domestic violence during his psychological evaluation. The evaluation noted that he did not share CPS's concern that domestic violence was a problem in the home and concluded that the respective points of view presented by Mr. Lison and CPS cannot be more dissimilar, unquote. Because he responded to the evaluation in a defensive manner, it was difficult for the psychologist to address whether he had psychological factors which may impact parenting, but it was clear that he had presented, quote, with a level of distrust for court and CPS that is hindering his ability to address parenting concerns. His prognosis was deemed guarded. But Dr. S testified at Disposition that an improvement period really ought to be granted. It's not here in this order. B. Like her husband, Stephanie Lison did not admit to any domestic violence in either her psychological or psychiatric evaluation. In her psychological evaluation, she reported instead that her husband had never been physically abusive towards her and that the whole situation had been blown out of proportion by CPS. She claimed that the adult respondents had been targeted because of their lifestyle. The psychiatric evaluation was undertaken in an effort to show that she did not fit the profile of a battered spouse and to offer a different hypotheses for the injuries she suffered, which she told the psychiatrist were either accidental, self-inflicted, or the effects of being a sexual masochist. I did not claim that any of those bruises were the result of sex play. That's a lie. He determined that she had 2 psychiatric diagnoses as follows: personality disorder not otherwise specified with narcissistic traits. That means no personality disorder, you moron lawyers. And 2, paraphilia, known as sexual masochism disorder. That's the old-fashioned stuff that Dr. M explained that, it's outdated, but that he also said that I should be granted an improvement period and that, okay. In describing the narcissism, the psychiatrist reported that Stephanie Lison demonstrated traits including a sense of specialness, air of superiority, and tendency to devalue the opinions of others. He explained that narcissists have difficulty following rules and generally do not believe that rules apply to them. That's not what he said. Further, that treatment of a personality disorder is difficult and can only be successful when the patient wants to change, evidenced by admissions. He testified further that the indicators are that Stephanie Lizon is quite pleased with herself and sees no need to change. That was... Do I even need to say? I hope not. She does not see herself as a person who needs therapy or counseling. I didn't say that. Believes that she has special privileges and talents as a mother towards my own children, that I might be specially qualified to parent my own children. And is in frequent conflict with CPS, yeah, because they were holding my children. Wanted me to wear a specific kind of deodorant. He opined that even if she were receptive and motivated to treatment, it would be a long process. Although his evaluation predated the adjudication admissions by about 60 days, Dr. M's testimony described exactly the behaviors and attitudes that this court has witnessed from Stephanie Lizon throughout the pendency of these cases and the guardianship case. 10. Both adult respondents at disposition were cross-examined extensively. Why at disposition? At sentencing were we cross-examined extensively about the domestic violence which formed the basis for the removal of the children. Significantly but unaccountably, this is my favorite part. Let's start again. Significantly but unaccountably, Stephanie Lizon had difficulty testifying as to what exactly her husband had done to her, which constituted domestic violence. I had difficulty testifying during a 16-year marriage what exactly he'd done to me that would constitute domestic violence. After the court allowed her a break and the opportunity to consult with her counsel, who was objecting vociferously at this point because we were getting cross-examined at sentencing instead of at the trial where we pled guilty, she admitted only that he'd slapped her in the face, bullied her, and grabbed her. She said that she was working with her therapist to recall incidents of domestic violence, what led up to them, and how to prevent them, but was unable to clearly define every incident that occurred. I was unable to clearly define every incident that occurred. I was unable to clearly define every incident that had occurred. The court finds that this testimony was inaccurate, deceptive, and an effort to manipulate the court not worthy of belief. Peter Lizon testified in more detail and was able to recount instances primarily of bullying his wife. However, he also admitted that he has problems defining, quote, the line between domestic violence and sexual activity. Fuck. Neither adult respondent in their respective testimony corroborated the infliction of severe domestic violence established during the evidence presented at the preliminary hearing in these cases. There's no such thing as severe versus just domestic violence. It's just domestic violence in all the statutes and the policy of the DHHR. Findings of fact, point 11. Although the Uniform Child and Family Case Plan submitted by the petitioner DHHR indicates that this was an agreement, the guardians ad litem and CASA objected to the plan, and both adult respondents, while seeking periods of improvement, are not satisfied with the terms and conditions as proposed. The guardians ad litem and CASA have taken the position that an improvement period is not warranted in this case, inasmuch as the admissions made by the parents do not appear to be genuine, although accepted by the court, nor a clear acknowledgement of the serious problems which caused the children to be removed. Not just the problems, we admitted to the problems, but we didn't say they were serious enough. And because past actions in this case and the testimony of the adult respondents show that they will not follow rules set forth in the case plan and ultimately ordered by the court. For instance, the adult respondents each testified that they did not believe the case plan's requirement of parenting education, like how to change diapers, was necessary, and they did not believe the services offered in the plan were specifically tailored to their needs. Services we offered to pay for and were, in certain cases, paying for. specifically tailored to our needs. The position of the guardians ad litem and CASA is substantiated by the evidence. 12. Both adult respondents have already begun services which they believe should constitute their case plan. Both are in therapy at whatever psychological group, including individual and joint counseling. The audacity of us. Stephanie Lizon is attending the EVE program and a support group at the YWCA for battered women. Peter Lizon is attending BIPP, an education program designed to be an intervention for batterers. They have testified that their therapists have provided cell phone numbers where they may be reached 24/7 in the event of a crisis at home, since they have now reconciled and are living together. According to Stephanie, both she and her husband had, quote, such a positive immediate experience when they began to seek external help that their problems are being resolved to their satisfaction. From the parents' testimony coupled with the psychiatric and psychological evaluations of record, which they, not the WVDHHR or the court, arranged, we went to our counselors and paid for it ourselves. She has that underlined as evidence that it's bullshit. These are the same doctors that the state regularly calls as experts. Same people, but because we paid for it, she says that it's funny you'd admit that. When it's funny you'd say, well, everybody knows that the experts aren't going to testify for the state if they're not paid by the state. We should have let the state pay them first before we paid them, because then it would be the state that would get the finding they wanted. And this is the guardian ad litem admitting that this is so. But when the state uses it to its advantage to get false testimony based on money, it's okay. But when a respondent uses their own money to hire the same expert to get the results that they paid for, that's absurd. Okay. The court can only conclude that these efforts are not sincere. We weren't sincere, as neither adult respondent believes that there are currently any serious problems to address. That's, well, clearly not what we said based on the admissions, right? Moreover, there is ample evidence that both adult respondents have lied repeatedly, testifying to whatever set of facts is required to achieve the results they seek. We never achieved any results that we sought. This, the court believes, is the rational and reasonable explanation for the twists and turns that this case has taken. Not vacations for all the attorneys. No. The purpose of an improvement period, this is 13. The purpose of an improvement period is to afford the abusing parent an opportunity to rectify the conditions of abuse and neglect which caused the filing of the petition, so that the child or children may be safely reunited with the parent. They quote case law. However, entitlement to an improvement period is conditional upon the ability of the parent respondent to demonstrate by clear and convincing evidence that the respondent is likely to fully participate in the improvement period. The guardian ad litem, the one that loved my daddy so much, the Republican, her husband was a state legislator and had, a few months before our case came to hearing, introduced a bill saying that the DHHR and the courts did not have to grant a parent at least one improvement period. This is the law that her husband made had recently been ratified, and she used it to deny me a single improvement period after my admissions were made. Further, the court has emphatically ruled that both statutory and case law emphasize that a parent charged with abuse and or neglect is not unconditionally entitled to an improvement period. Where an improvement period would jeopardize the best interests of the child, for instance, an improvement period will not be granted. Clearly, the adult respondent who is seeking an improvement period has the burden to prove that an improvement period is appropriate, i.e., that they are likely to fully participate in the improvement period. 14. In case law, the court reiterated that in order to establish they were likely to participate in an improvement period, the parents were required to acknowledge that the child had been abused. In order to satisfy the requirements of West Virginia Code blank, the parents must make this important initial acknowledgement. While the adult respondents in this case made admissions at the adjudication hearing, it is clear from their own testimony at disposition, as well as the psychological and psychiatric evidence presented, that neither parent was genuine in the admissions that the court accepted. And neither has acknowledged the severe domestic violence in their home and the danger it causes to their young children. Who, due to their young age, are completely unable to protect themselves, also completely unable to change their own diapers or drive a car. And one of them unable to walk. Neither of them being able to say clearly, "Give me back to my mother, you fucking bitch." Okay. In fact, the testimony of both adult respondents at disposition minimized the serious violence which had occurred in their home. Their records of dishonesty with this court, magistrate court, mental health professionals, doctors, DHHR, CASA, law enforcement, and other case personnel cannot be ignored. Moreover, their extensive record of disregard of rules and orders, as detailed in the findings above, clearly demonstrates that they are unlikely to fully participate in an improvement period. Particularly when they're already raising objections to a case plan they believe is not tailored to their needs. As Peter Lizon has testified, he only obeys orders and rules which he believes are quote-unquote just and lawful. Only obeys orders and rules which he believes are just and lawful. Why would the DHHR need to protect orders that are not just and lawful? 16. Based on the foregoing, there is no reasonable likelihood that the conditions of neglect and abuse which caused the children to be removed from the custody of the adult respondents can be substantially corrected in the near future. And continuation in their home and in their care is clearly contrary to the children's best interest. In fact, after substantial testimony over several days, this court has earlier found that there is imminent danger to the children while in the Lizon home. These young children need continuity of care and caregivers, which is currently being provided for by the state in a foster home. Reunification with the adult respondent parents is not in the children's best interest because both adult respondents lack the sincere desire to admit and conquer the serious domestic violence occurring in their home. Both of us lack the desire to conquer the serious domestic violence occurring in their home. One sentence, both of us. He, apparently the desire to beat, and me, apparently the inability to prevent it. That's the same, according to family court. The same. Explain it to me. Next. I'm going to read from here again. Reunification with the adult respondent parents is not in the children's best interest. Parents, there's no option for one or the other. Because both adult respondents lack the sincere desire to admit and conquer the serious domestic violence occurring in their home, placing the children at substantial risk. Because of the total lack of cooperation of the adult respondents at the time of removal, no reasonable efforts to reunify the family were required. That's right, no efforts to reunify the family were required on the day that, whatever. 17, there is no less restrictive alternative available to the court but termination of parental rights. It is necessary for the best interest and welfare of two very young children who are wholly unable to provide for their own safety and protection. What children are? 18. Continuation of the infant respondents in the home of the adult respondents is contrary to their best interest and welfare because of the risk of substantial emotional abuse resulting from domestic violence. Emotional abuse resulting from domestic violence. West Virginia Code says that you can't remove a child for emotional abuse, only when there's no physical abuse or physical neglect. And yet this was done. There's no explanation for that. Case law, bench book. 19. In determining that it is necessary that parental rights be terminated in this case, the court has considered the need of the children for continuity of caretakers. This factor does not have the weight that it might in other cases. However, the parent's failure to acknowledge the true nature and severity of domestic violence, together with Stephanie Lizon's chronic mental health disorders, amounts to a situation where the court is wholly unable to determine when, if ever, the parent's home will be a safe place for the children. Really, I exhibit mental health disorders. Wanting to beat me is not a chronic mental health disorder. No, ladies and gentlemen, it isn't. Actually, wanting to beat your wife isn't considered a mental health disorder. Boys will be boys is what it's considered. Boys will be boys. But a woman who can't get away, mostly because of the court, that's a mental illness. That's a mental illness. Being beaten is a mental illness, boys and girls. Being beaten, getting beaten is a mental illness, but beating is not. The risk of continued substantial emotional abuse to these children outweighs the fact that continuity of caretakers does not appear to be a significant factor in determining whether find that determination of parental rights is the children's best interest. It makes no sense. 20. The recommendations of West Virginia DHHR that the court grant the motions for post-adjudicatory improvement period. Hear this again. The recommendations of West Virginia DHHR that the court grant the motions for post-adjudicatory improvement period filed by the respondent parents are not consistent with the evidence. The petitioner is wrong, says the guardian ad litem and the judge. The petitioner the DHHR wanted to give us improvement periods, but that wasn't consistent with the evidence of who nobody knows. And to grant such motions would not be in the best interests and welfare of the infant respondents. So the DHHR was totally right in taking them, but totally wrong in wanting to give us improvement periods, with reunification of the family being the goal. Totally wrong. Finally, order. Based on the foregoing, quite a bit of foregoing, it is adjudged and ordered as follows. A, the parental rights of Peter Lizon and Stephanie Lizon to the infant respondent ML and BL are permanently terminated. Their respective motions for post-adjudicatory improvement period are denied and overruled. B, legal and physical custody of the infant respondents is awarded to the West Virginia Department of Health and Human Resources with the authority to consent to the children's adoption. C, pursuant to Rule 49 of the West Virginia Rules for Procedure for Child Abuse and Neglect Proceedings, the adult respondents are advised of their appellate rights as follows. The adult respondents have the right to appeal this order terminating their parental rights to the infant respondents. We do and did. Is another one. 2, if the adult respondents choose to appeal the termination of their parental rights, their respective counsel shall be reappointed to prosecute an appeal to the Supreme Court of Appeals without charge to the adult respondents. How nice. 3, if an appeal is desired, a notice of intent to appeal must be filed with the clerk of the Supreme Court of Appeals of West Virginia within 30 days after this order as filed in the circuit clerk's office, and a petition for appeal must be fully perfected within 60 days of said date. Otherwise, the right to appeal will expire. The appeal may be filed without a transcript. D, the adult respondents and their counsel are dismissed from further hearings in this matter. E, the parties shall convene an MDT as soon as possible to determine a recommended permanency plan for the infant respondents. F, the hearing scheduled for May 2nd, 2014 at 1 p.m. is canceled. The court will confer with counsel to schedule the permanency hearing after the MDT. G, all future visits of the children with Peter Lizon and Stephanie Lizon are terminated. The clerk shall provide copies to this order to all counsel of record, CASA, and to MA CPS worker, all of which is ordered accordingly. Entered May 1st, 2014. TCE, the Third Circuit Judge. Well, there it is, ladies and gentlemen. The order. Both I and my then husband did appeal these decisions, and the appeals turn out to be fun reads as well. And if any of you still have any lingering doubts as to the relative justice of this, please stay tuned for the reading of both mine and the ex's appeals. Also, at least those were separately considered, maybe, not really.